Medicare as secondary payer compliance in only 15 questions. This presentation is for instructional purposes only. It's for CLE credit, 1 hour. To comply with credit, you must receive our handout, okay, and sign in. Please participate. I do not have an hour's worth of material. I have like 25 minutes tops of material. So hopefully people will ask me and try to stump me on Medicare questions. And Tim said, Greg, I usually don't like to make you look foolish in front of everyone and ask questions, but today he's going to. So please do that. All right, our presentation today is based on 42 USC 1395Y, as also known as the Medicare Secondary Payer Statute. We've all read it. We love it. We live it. And also the new reference guide, which was just published a couple of days ago, actually, and is now the official reference guide. It is not binding law, the Center for Medicare Services Medicare Secondary Payer Reference Guide. It is just their advice and guidance. But we do believe it is best practice to try to comply with the recommendations and guidance in the reference guide. So if you ever get really stumped and you're like, how does this work? There's good examples in there. It's actually a really good material. Some things that are making this extremely timely. Again, first of all, we always revisit Medicare as secondary payer every year in our training. Why? I always argue that there are only 3 things that separate the truly master of their craft workers' compensation defense attorney or defense paralegal and the ham and eggers, the turnpikers, the dilettantes and the tourists in our courts, right? The 3 things are: 1, great experience and accuracy in pricing a case, right? How much is this case really worth? That foresight, the claim sense that you have. Okay, that's one thing. Second thing, a real deep understanding of risk transfer. What a great opportunity for our clients to take control of the case. And the third thing is Medicare as secondary payer issues. They're going to crop up in a lot of our cases, and the true expert or master of their craft is comfortable guiding clients through Medicare as secondary payer issues. Okay, so these are the 3 things that separate the real pros from the amateurs. And this is something that I want us all to be very conversant and comfortable with. So 2 things make this topic timely. First, we revisit it every year because you need to know it, and it's really important. The second is the workers' compensation law, section 21A, which comes into play in all of our controverted or denied cases, is going to change January 1st. And it's going to change, and the statutory change says that our clients can now start paying for medical, can start paying lost time in cases for up to a year without any prejudice. That's useful because if at the end of your case, when you reach your section 32, your full and final settlement of the case, if you haven't paid anything, at the end of your case, it's time for us to resolve under section 32. If you can make an argument that this was controverted from the beginning, you can make an argument that there should be a 0 set aside or a 0 conditional payment reimbursement or a set aside, right? So that's useful to us. So that's going to be helpful next year, 2027, when the new statute kicks in. All right, the second reason this is timely, it was in the news a couple of weeks ago. Social Security is running out of money again, right? And they now say that they will become insolvent as of 2032. As we all know, Social Security is a Ponzi scheme in which the current people that are employed pay into a system and pay for people who have already retired. If what happens are less people are in the workforce than there were 30 years ago, guess what? It goes insolvent, and that's what's going to happen in 2032. The reason that's important to us is because as Medicare gets closer and closer to becoming insolvent, they're going to be more and more predacious and more strict about interpreting our requirements and our obligations under the Secondary Payer Act. So we can expect this to amp up as they start to run out of money in the future. Okay, they're going to be even more motivated than they have been in the past. All right, so basics of Medicare secondary payer. We're going to talk about a little bit about what is the act, what are our obligations, what's our responsibilities, and they're all on us, what we do when we have a settlement, and we're going to go through some terminology. But my real goal today is just to get us into these 15 questions that we answer in every case while we're going to do a full and final settlement, right? I think my role primarily is to try to reduce things and make them as simple as possible. If you answer these 15 questions with a yes or a no, you will know if you have a Medicare entanglement that you have to unwind or guide your client through. You can't go wrong if you answer these 15 questions. So what does the act say? The act essentially says Medicare can never be expected or obligated to pay for anything that a primary payer should have paid for. And that could be primary health insurance, that could be a motor vehicle policy, That could be a civil liability or a workers' compensation obligation that the employer or carrier has, right? We could never shift that burden to Medicare. That's all this thing says. Now, this thing's been on the books since the 80s. I think 1984, they passed this because that's when they first started to realize this Ponzi scheme called Social Security is going to run out of money at some point. They never enforced it until 2001. And then in 2001, they started enforcing this section of the statute because back in 2001, they started realizing, hey, we're running out of money and we got to stop all of this loss that's going on right now. So that's what it stands for. That's what it means. It essentially says we're always primary to Medicare. If the workers' comp carrier or employer is obligated to pay, they must pay. Medicare should never pay. We should never shift the cost of our medical treatment onto Medicare. And that's our obligation, okay? So this has come up in office hours recently, and I think one of the things someone said to me in office hours was, oh, well, the claimant's attorney says that you're not responsible and there's no Medicare. I'm like, well, that's cute. They can say whatever they want. Our client has a separate legal obligation to meet, okay? So even if your adversary, opposing counsel in a case is telling you, we don't have to take Medicare's interest into account, don't take their word for it, okay? You've got to do your own separate compliance analysis and make sure that we're not doing something that's going to obligate Medicare for something our client should have paid for. We can never shift that burden to another party. All right, so it's important for a couple of reasons. The first, if Medicare does make payments on behalf of a claimant that we should have made, right, as the responsible workers' compensation carrier, they can come after the claimant, they can come after their claimant's attorney, they can come after us, the workers' comp defense attorney, and they can come after the employer for those payments that should have been made by the workers' comp carrier. Okay, so that's number one. There's liability that attaches. If we don't reimburse them, they can start charging interest and they could start trying to hit us with penalties. If they find that we did not comply with our obligations under the Secondary Payer Act, they can make a penalty payable by our client. And this is most dangerous in my mind when it comes to future obligations that we might be shifting to Medicare. So we have a person with a low back injury that's going to need a whole bunch of treatment or surgeries in the future. 10 years after we close our comp case, they run their back surgery through their Medicare card. And it costs $100,000 to Medicare. Well, Medicare is not going to just come after our client for $100,000. They're going to come after our client for $200,000 because they're entitled to a double penalty. So be very mindful of this. This thing really does have teeth. Our clients have additional responsibilities under Section 111 of the Act, which is a reporting requirement. And it essentially says that every workers' comp carrier and every self-insured employer is a responsible reporting entity, an RRE. And they must do a match, a Social Security number match with Medicare, with Social Security for every single workers' compensation claim. So even where your adversary tells you like, don't worry about this, or your client's like not paying attention to it, they should have been doing a match in the background. Medicare is going to catch wind of this settlement at some point, and they're going to catch up with us. Okay, so we need to be very thoughtful about protecting our clients. Two of your cases that are going to be impacted are the case where the claimant currently has Medicare. Also, by the way, some of these silly hearts, they don't even know they have Medicare, right? Look at my in-laws. They are now on Medicare Part C plans, which are called Medicare Advantage plans. You see them advertised every January because that's when the open enrollment period is. Every commercial during daytime TV, you know, for the kinds of people that sit home and watch Judge Judy and daytime TV, they see all these ads like, hey, now's your time to enroll in Medicare Part C Advantage plan. And they get a card that says Humana on it, or I'll say Blue Cross Blue Shield Empire. And they won't even think that they have a Medicare plan, but it actually is a Medicare plan because we privatized the administration of Medicare benefits through these insurance companies. Okay, so we have to be thoughtful about that. And any full time you're doing a full and final settlement where the claimant has a current entitlement, right? So these are the circumstances where we're going to have to be thoughtful about our obligation. Now, if Medicare's already paid for something in your workers' comp case, they have a special Medicare term for that, which is a conditional payment. It just means they've already made a payment in your case, all right? And the second time we have to be concerned is we're closing a case, we're foreclosing future medical, we're doing a full and final, hooray, awesome. But we're foreclosing future medical and the person could be Medicare entitled. What's going to happen? Medicare might be future obligated and we have to resolve that or take care of that. Medicare says that it has a quote future interest because they might have to pay for something related to the comp case in the future. Those are the two danger zones that we live in. All right. Now, true mastery of this subject or any subject, I believe, is if you can make something complicated simple. So the 15 questions you see in front of you are my attempt to simplify this. So as you go through a case and you're sitting there and you're saying, hey, do I have to worry about any of this gobbledygook? Do I have to worry about federal compliance? Do I care about any of these things? I promise you, if you get through these 15 questions, you will absolutely know the answer to this. And you don't need more than 15 questions. You might need less. You might be able to answer this for yourself in the second or third or first question even. You'll know, wait a second, I got a Medicare interest I have to take into account, and then you'll be guided on what to do next, all right? So first things what we're gonna go through is what's Medicare status of the individual. Second thing we have to go through is, has Medicare already paid for anything in our workers' comp case? Potentially, okay? Third thing is, am I closing out a future medical, or is there a potential that my client is gonna shift the obligation for future medical treatment to the federal government? And the last thing is, all right, if all of that's true, will Medicare even review my proposed way of resolving this, right? So those are the questions that we need to go through. I printed them out. I made them as a handout. And as you'll see in a minute, we also created a tool that's going to support this as well. But I don't think there's 16 questions. And again, you might not have to get through all 15, but if you get through these 15 questions, you will know the answer. All right. So first questions that we have to answer in every case that we're defending that's going towards a full and final settlement. Now, if you're resolving a case on a SLU, on a LWEC, on a stipulation, do you have to worry about this? No. Only in a Section 32 lump sum dismissal. Goodbye. God bless you. Your journey with us has come to an end. That's the only, and where medical is closed. Okay. So the first question you have to answer, is the claimant currently enrolled in Medicare? Please do not rely on age alone. Please note that if someone's applied for Social Security disability and gets Social Security disability, they are automatically entitled to Medicare 2 years after they are found eligible for Social Security disability. So they'll automatically transfer. You could be 22 years old, you could be 20 years old and be found Social Security totally disabled and therefore eligible for Medicare. And here's the dangerous moment. Medicare's Social Security disability determination can go back in time. Okay, and so they can say, you applied for Social Security disability in 2026, but you were actually disabled in 2023, and they can go back 2 years in time and find the person disabled as of that time, which will make them automatically and immediately entitled to Medicare. So as your case is pending, you can look at it and be like, well, I couldn't possibly have been on Social Security disability yet because it hasn't been 2 years from the date of loss. But actually, by the time Medicare makes that determination, they can go back in time. So just be very thoughtful about that. Please also think, we're not just talking about traditional Medicare. Traditional Medicare was Part A. Okay, Part A was hospital service, and then Part B became private health services. Now we have Medicare Part C and Part D. Part C is those advantage plans that the silly-hearted seniors get themselves involved in and don't even realize they're on Medicare. And Part D, we can thank George W. Bush for when he brought medications under Medicare's wing. Okay, so someone could have a medication card. So all of those things that we have to be thoughtful about. Now, our practice here at LOIS, and it's best practice, is at intake every single case, no matter what the case comes in for. Even if the client sends this case and says, this case is settled, just settle it. We're sending out a Medicare affidavit to the claimant, right? And it says, please tell us if you're on Medicare, you have to fill out this affidavit and return it. Now, has anyone actually ever seen claimant return a Medicare affidavit? Not a lot, right? Now, Declan's saying I saw it once. Very rare, but ask for it. Okay, this is a wonderful thing to ask for at those hearings. Like, Judge, I asked them to tell us if they are or are not on Medicare. It's one of your big signals. Another thing we should do is ask your client. Okay, your client has that Section 111 responsibility as a responsible reporting entity, an RRE, to do a Social Security match between their employees who have made a workers' comp claim, any kind of claim, if it's medical only or indemnity only, any kind of claim, and the Social Security system. Okay, so they can tell you as well, and they all have the facilities to do this, so they should be able to tell you that. Okay, so first question, is a claimant currently enrolled in Medicare? And now you know how to answer it. Okay, second question, if they're not currently Medicare entitled, do they have a reasonable expectation of entitlement within the next 30 months? Okay, and then Medicare defines in the reference guide what they believe is a reasonable expectation. 1, they've applied for Social Security disability benefits. 2, they applied and were denied Social Security benefits and are going to appeal. 3, they are appealing or refiling. That's really important because something like 50% of people who apply for Social Security disability, get denied the first time, and then something like 80% of them get Social Security awarded the second time they apply. So that's a really big tell that they're going to be on Social Security. The third thing is they're 62 and a half years old. Why? Because at 65, you're automatically entitled, right? That's the earliest you could take Social Security retirement, okay? And the last thing is they have end-stage renal disease. Why is that in there? Because when Social Security was first passed, or sorry, Medicare was first passed, it was only hospital service for you're gonna die soon or you're in kidney failure. That was, they anticipated that the average person would be on Medicare for less than 2 years. Now it covers everything, covers anything you could possibly think of, right? And it also includes medications, et cetera. So that's an enumerated qualification to be Medicare entitled, right? So again, look at the age of the person, look at any of these other factors, and you might not know these factors. Have you applied for Social Security disability? You have to ask opposing counsel when you come into that full and final moment, right? Third, during the pendency of your case, was the claimant Medicare entitled at any time? Okay, now this is gonna be extraordinarily rare, but it is possible for someone during the pendency of our workers' comp case, because they don't all resolve in a year, right? An old case in particular, the person could be Medicare entitled for some period of time and then not be entitled anymore. Right? It's extremely rare. I don't think I've ever seen it, but it's a possibility. And that's why we put it in there. And the reason you have to be thoughtful about that is it means that during some period of time when we're defending and litigating this case, Medicare might have made conditional payments. You're not going to have to worry about future obligations or a set aside, but you would have to worry about conditional payment obligations, all right? So that's the first three questions. Now, if your answer to all of those questions is no, you're done. You don't go on after that point because you can't have a potential conditional payment issue. You're never going to have a potential set-aside issue, so you're done after those three questions. But if your answer to any of those three questions is yes or I don't know, keep going with the questions, okay? Next thing we have to think about is, all right, could Medicare have made any payments? Remember, they call those conditional payments. How do you find that out? Well, there's two ways. The first way is we can ask opposing counsel, can you have your client get us a conditional payment statement, right? The second way is we can talk to our client and say, can you have your vendor request a conditional payment statement? Unfortunately, as defense counsel, we can't request conditional payment information directly from Medicare, okay? So those are two ways you'd find out, right? The fifth question, were they enrolled in a Medicare Part C plan? Again, that's those Medicare Advantage plans that are a little bit sneaky and a little problematic for us, or a prescription drug plan, Part D, right? Now, pretty much every single Medicare recipient is also going to be in a Part D plan because they're all going to have some kind of medication. The Part C ones are really tricky, and particularly for conditional payments. And the reason for that is Medicare has a rule that if you're a doctor treating a patient, you have to submit your bill to Medicare to get paid within 60 days. Right? So that means that when we contact Medicare directly and the person's on direct Medicare, meaning not a Medicare Advantage plan, not a Part C plan, right? A Part A plan, Medicare can tell us, yeah, this person got treatment and it's going to be relatively up to date because the doctors have to submit those bills within 60 days. The Advantage plans have different billing requirements than Medicare itself. And they could be up to a year. I've seen some that are a year the doctor has to submit those requests for reimbursement. That's problematic for us because when we go to the adversary and we go, well, do we have any conditional payments? They'll go and check and they'll contact Medicare. CMS will immediately, it's very easy. The claimant themselves can go through a portal. They type in their Social Security number, tell you, here's what we've paid for you. But if they've got a Part C plan, which is administered by not Medicare, right? It's administered by a private company. They might not have even seen the bills yet. So those are more problematic. We have to directly contact their Part C administrator in order to find that out, okay? My advice to you is you're in this situation, tell your client, hey, we need our vendor to go get this information for us, all right? All right, the next set of questions we have to go through. What are the future medical obligations in our workers' comp case, okay? First, will the settlement close, release, end our future medical for this claimant? Hopefully, yes, right? My favorite kinds of settlements are full and finals, including medical. Please use our boilerplate and we're doing a full and final. Please include our language that says this for, be very clear, very specific. This is where the very few reported cases on this, federal cases, or where it's unclear who's responsible for future medical, but be extremely clear in your section 32. We are foreclosing future medical. This is a full and final. There'll be no further payments of indemnity. There'll be no further payments of medical. Okay, so if you know the answer to that one, well, okay, now we have to think about Medicare's future interest. Question 7, will the carrier or self-insured employer remain responsible for claim-related future medical care and prescriptions after settlement? Okay, in a case where you're not closing medical, it will typically be our client. Now, there are other things our client could do. They could set money aside. They could buy them a private health insurance policy that covers that body part or injury. Extremely rare, actually never seen it, even though it's theoretically possible. But how are we going to, who's covering the future medical? What do we know? What's the answer to this? Question 8, is the settlement genuinely limited so it does not shift at expected future medical costs to Medicare? How do you genuinely limit this? Well, generally it's going to be, I put a set aside, an allocation of future of these funds to take care of Medicare. I don't care, from my perspective as a practitioner, how we come to that set aside allocation. You know that I'm pretty agnostic, whether it's a legal determination, whether we use a vendor to price it, whether we use the reference guide method to price it. But typically, what are our clients doing? They're getting a life care plan from a vendor, right? And we're saying that's going to be our future set aside. So how specific is that? Do you have that? Are we making sure that we're not shifting exposure to Medicare? Question 9. Answer this one. Does the treating physician say they still are going to need future medical in the future? Again, in our cases, it is extremely rare for a physician to say that they're fine, they're ready for the Olympics, they don't need any more medical treatment with me, right? Most of our cases, they want to keep these people in therapy forever. Most of our cases, they won't find MMI. But let's say you have a cooperative opposing counsel. Many of us have gone to opposing counsel and said, look, we're trying to close this case full and final. I've got this crazy set aside. It's $300,000. And it's all because your doctor, your treating doctor, in their notes somewhere said, maybe someday he'll need a spinal cord stimulator, or maybe someday we'll need a new surgery or something like that. You go back to opposing counsel and you say, look, can you go talk to the treating physician and have them write a letter that says, no, he's not going to need a spinal cord stimulator, or no, that surgery is very prospective. He doesn't need that surgery, right? So you can have the treating physician eliminate the things that are driving up the exposure in your set aside. Like, that's completely fine. I've done that many times. We can do it. That's, just called being an advocate, right? And again, be thoughtful about undue influence. I prefer to have the opposing counsel, with my permission, confer with the doctor to have them change their opinion about the need for future medical. It's also a great point in settlement negotiations, particularly when you have your case that you're trying to settle for $100,000, Section 32, and the set aside comes back huge because it's including all sorts of crazy medications and a life care plan that's out of control and blows up your settlement. This is an opportunity to be able to work with opposing counsel and say, what can we do to work together to get that treatment that we all know is unnecessary and they're never going to get? Can we get the doctor to say they don't need it? And then we can reapply. We can do another set aside allocation based on that letter and eliminate that and reduce our exposure significantly. Okay. Medicare in its reference guide says that even if the parties in our Section 32 settlement, right in our Section 32 settlement, like, yeah, his doctor says he needs this spinal cord stimulator maybe someday, or might need a revision surgery maybe someday, but the parties agree he'll never get it. Okay, even if we wrote that in our Section 32, Medicare's position is, yeah, that's cute, but we really want to hear from the treating physician who authorized or who recommended that treatment. Okay, so that's really the steps we'd have to go to close that up. All right, number 10. If the claim is fully denied, does it satisfy all CMS indicators supporting a $0 future medical position? Because remember, we can argue that there is not going to be any future medical associated with this case. Medicare, we're settling this claim for $50,000. It really is nuisance value. They really aren't going to get any more medical in the future. This is a highly disputed workers' comp case. Well, Medicare is saying, well, we want to know how vigorous or how realistic that controversy really is, okay? And so they've said in their reference guide, here's all the things that they would consider. First, that responsibility was denied under state law within the applicable time frame. Okay, in other words, we controverted the case. We didn't make any payments except investigation payments where permitted. Guess what? next year, starting January 1, 2027, you can make a year of payments and call them all investigatory and without prejudice and not trigger this provision, right? So that's going to be incredibly useful for us in arguing for a zero set aside in a case that's maybe accepted without liability and then we later controvert and deny, right? And we all know what happens in a comp case when you say to the law judge, hey, I'm denying this case, it's denied. We have all these, and the judge says, well, you already paid for medical in this case, or you already paid for lost time. Well, that's not going to be something they're going to be able to stand on next year, starting in January. So be thoughtful about that. We're not currently paying medical and indemnity benefits, and the settlement does not allocate specific amounts for past or future medical or pharmacy services. In other words, we're essentially saying, as we defended this case, first we're investigating it, we're not sure, it's without liability, and then we're saying it's not us, right? So they're going to look at the strength of the controversy in determining whether a set aside is going to be necessary. So these are all things that are going to be helpful to us. All right, the next thing the question we have to ask is, has a law judge or the board come back and said this is not related or no additional medical is going to be payable in our case? Now, we know in our cases, even if we win amazing fraud decision, we're still on the hook for medical. So you would really need a judge to say, this is disallowed, it's not causally related, this body part should be excluded, it's not established, I'm sustaining that. That's what you would really need. Again, exceedingly rare, but this would come into play when you're settling the case post determination by a court, okay, post. And again, it would be a favorable determination as well. Next, we have to ask, does the medical record or other facts indicate that the claimant is likely to require future claim-related treatment or prescription drugs? Okay, I think in every single one of the cases we're going to defend, there's a doctor somewhere saying they're going to need future medical, right? Again, that's going to trigger that secondary payer obligation that we have to be thoughtful of. All right, final question before we get to review thresholds is there any material diagnosis, body part, or future care recommendation which is disputed? Again, this can help us eliminate or avoid a future set aside if we have a doctor's opinion that says is contrary to the treating physician. But throughout the reference guide, everything I've ever read, Medicare said we're always going to weigh the treating physician more than your one-time IME that says they don't need future medical. Okay, so even in this case, I still think we're taking Medicare's future interest into account. All right, the last two questions we have to answer for ourselves. And again, if any of the questions before this, any question 1 through 13 is yes, okay, the next thing is, all right, is Medicare going to even review the proposed way we solve this problem? And that's the review eligibility. And again, this is the thing that separates the amateur from the master, because I consistently see attorneys confuse a review threshold with some sort of safe harbor, right? But these are not the same concept. Is the claimant currently Medicare entitled and the CMS total settlement amount greater than $25,000? Yes, Medicare will now review your case, right? That's the review threshold. Medicare has their own definition of what total settlement amount is, which is kind of interesting. If you read the reference guide, it includes attorney's fees that we're paying. I do this in my Jersey cases. I don't really do this in our New York cases, but in my Jersey cases, when I'm trying to settle a case and my adversary says to me, well, Greg, the guy needs to clear $15,000 or he's not going to settle this case. I'll say, all right, I'll pay him $15,000 on a Section 20, which is a lump sum dismissal, plus I'll pay your fee of $3,000 on top of that, right? Might be useful to you in a Section 32 where you say, well, I'll pay, your guy needs to clear 20 grand, fine, I'll pay him 20 grand and I'll pay your fee of $3,000 on top of that. Well, Medicare is saying, when you do that kind of thing, you have to include both of those payments, even though one's to the attorney and one's to the claimant as the total settlement value. Okay, so if you do use that negotiation trick or technique, be thoughtful. If you settle for example, you settle your workers' comp case for $25,000 because you're trying to avoid review, submitting for review, and then you also agree on top of that to pay a $4,000 attorney fee, you're now above $25,000. All right, I hope that makes sense. The second thing is any lien payments that we make. So a case where you have to reimburse their primary care provider, or they put something that wasn't through Medicare, or you had to reimburse this temporary disability lien. Medicare is going to count that towards your total settlement value. So be thoughtful about that. And then any amounts forgiven by the carrier. And again, that would be your waiver situation. You've got a Section 29 waiver. That would count towards your total settlement value if you're waiving reimbursement from a civil action, right? We do that all the time. And the last thing is prior settlements of the same claim. And this is specifically in there because I've had cases where my adversary has said to me, hey, we've got 2 cases against you. I'll settle this one for $12,000 and this one for $14,000. And that way they're each below the $25,000 review threshold. Does it ever happen to anyone where they think that's some kind of safe harbor? And I'd say like, no, first of all, that doesn't actually work. But also if they add up to more than $25,000 together, now you have to take Medicare's, you have the potential for a review. All right, the last thing, time that could trigger a Medicare review of your proposal is if the claimant's not currently Medicare entitled, but has a reasonable expectation of Medicare enrollment within 30 months, and the settlement amount exceeds $250,000, right? Those are the 2 times when you'll get a review from Medicare. Since the last time I taught this, last August, my position has always been we should encourage our clients not to do a Medicare review of a proposed set-aside, right, a future allocation. I think since then, I think pretty much all of our clients have spoken, and everyone says, no, Greg, if the case is eligible for a review, we prefer the review. I think there are some exceptions to that, but most of our clients want us to get a Medicare reviewed and blessed set-aside allocation. They want that letter from Medicare that says, we looked at this, this complies. They feel like it's an extra, suspenders and belt and a fire blanket that they're wearing around them. Okay. And for that reason, even though my advice to clients is in general, we tell them not to submit. Seems like most of them want to submit. Again, that's their choice. It just slows things down and includes risk, right? The risk is that Medicare comes back and goes, you guys are going to put $300,000 aside? We think you should put $400,000 aside. And that just increased their exposure. Most of our clients are choosing to do that. And again, let the client guide you on what they want. All right. Some takeaways. I told you this was going to be quick today, right? And there's a reason it's quick, by the way. Medicare's interest must be considered when there's a conditional payment or when the case is closing full and final and the claimant's eligible or entitled or has a reasonable expectation. That's the basic rule. A review threshold is not a safe harbor. It's the number one thing that we have to counsel attorneys that are not here. If you're waiting until settlement to address your Medicare secondary payer obligations, you've probably waited far too long because this is now going to slow you down. Whatever momentum you have towards settlement is going to have to slow down. Also, if you wait until settlement, we already talked about a 32 number, and then you have to go and get a set-aside allocation. It could be huge, and it could blow up your settlement, and there's nothing sadder. I mean, there's nothing sadder than that. All right. Who has a Medicare question for me? I love Medicare. Again, this is an opportunity for us to show off. We could show our clients like we're the 1% of attorneys who actually understand secondary payer obligations and how to apply them to your workers' compensation case. Jeremy, I'm calling on you last because I know you're going to have the hardest question. Tim, no, you don't. You have one. Okay. All right.
I may have a question. Is this working? Okay. So first of all, I was just telling the guys here that learning more about CMS is one of the reasons I switched to the carrier side, which is a legitimately true fact.
Because you loved it so much, you said to yourself, "This is something."
Well, no, because I didn't understand. I didn't really understand what I was talking about when I was representing claimants, and that didn't feel good, right? So I wanted to learn more about that, and I think we know that a lot of the time when we talk to claimants attorneys, they don't really know like what the requirements are or the difference between the safe harbor and the review threshold. But my question along those lines actually is, so like I remember recently when they revised the guidelines, there was a provision that the claimant could be responsible for their Medicare treatment up to the full amount of the Section 32 if the set aside is, after the fact deemed to have been insufficient. And it seemed like for a brief period in time, claimants' attorneys were very attuned to that fact. And that seems to have waned quite a bit, right? They don't seem to really care as much. So I was wondering, is that still in effect? Is there any reason that claimants' attorneys would have stopped caring? I mean, every now and then you have an attorney who's pretty insistent on getting a CMS approval, right? And that seems to be the safest route for everybody involved. But, it just seems like they don't really mention that anymore or seem too concerned about that anymore, but that still remains the case, right?
Yeah, so there's two reasons for that. So what Medicare is doing is when the claimant has essentially stolen from Medicare by shifting the exposure to Medicare or squandering the set aside, which is another thing they could do, when those things happen, or they don't take Medicare's interest into account, the first thing Medicare does is they just stop paying claims for that claimant up to the value of the Section 32. So what happens is the claimant has a bad back who keeps presenting their Medicare card and trying to get treatment for their back. They're going to just keep getting declined, and then they're going to get directly billed by the provider because Medicare is declining, right? Because Medicare has realized, well, these people took the money from the 32. They didn't put it in, bury it in their backyard. They spent it on a gold flake fishing boat and went bass fishing for 3 weeks, or they went to Atlantic City and wasted it. So they know there's no more money there. So what they actually just do is freeze their benefits. But then what they do is they come after every other party, which could even be the attorneys, it could be the carrier, it could be the employer, for the amount that Medicare believes it was shortchanged. So the exposure is ours. I mean, the fact that they don't seem to care about it is because the harm that their client is actually seeing is that their Medicare benefit just got frozen up until Medicare says, you've now expended $100,000 that should have been spent on future medical. And okay, now we're at $100,000 in one, we'll turn your Medicare card back on. That's how that practically works. So the idea of Medicare coming after the claimant and somehow being able to grab the money back from them never really actually happened. They just froze their Medicare benefit.
Okay, but is our client liable for any of that difference?
Yeah, because, well, in that instance where the claimant has a set aside, but essentially embezzles it and didn't use it correctly and still was charging Medicare, no, our client, we will have to make the argument, no, Medicare, we did take your interest into account. We funded the set aside. The money was there. The claimant essentially embezzled it from themselves and squandered it. And that's our client's defense. That's why this is so important. But if our client hadn't put a set aside in place, then our client would be responsible for reimbursing Medicare. And Medicare will come after them for penalties, up to double the value of the treatment that Medicare actually spent. So that's why the danger is to us. And this is always like a backwards looking compliance process where it could be 10 years from now. We could have closed the case when we first opened the firm in 2015. Now the person's squandered their set aside and just charging Medicare for it. I'm not aware of a statute of limitations for this, that Medicare can keep coming after us for not taking their future interest into account. No, so that's the danger. All right. Good question. Olivia had a question. I hope it's a softball.
There's times when I've settled cases, like when both parties are MMI, and, I've never really seen a treating doctor say, oh, the claimant's MMI, but still needs maintenance care. Would you consider that still need for future care, even though they're considered MMI?
And that's what stinks. If you look at the reference guide method, the reference guide method for calculating future lifetime care, it's literally like, oh, they need to go back to the orthopedist once a year, times whatever their life expectancy is, and that becomes the set aside. So even if it's ridiculous, and we see ones in there where it says like, oh, they're gonna have to get an MRI every 2 years. Like, no, they're not. No one gets an MRI 10 years after. But they build it in, and that's why these life care plans become so high and blow up these kind of rinky-dink settlements. All right, other questions. All right, Jeremy, hit me.
Just can you clarify two little things? For a lot of the time, we'll settle indemnity and then we might settle medical 10 years later. Thresholds, we have to take both into consideration when doing the review thresholds. Okay, because I think a lot of people here probably don't think about that at all.
Right, and that's why the reference guide now specifically says there could be multiple settlements in the same case. You add them up. If they exceed $25,000, now you have a review opportunity. Doesn't change your obligation, doesn't change what our requirements are, but then you would have that opportunity to get Medicare to bless it.
And the other one is $0 MSAs and these reports. A lot of the clients want to use these now. What is our position on those?
I love $0 MSAs. I mean, let's be realistic. I think we should be practical about it. Medicare has said they will not review $0 or approve $0 MSAs. Right? And I mean, that's their position. Okay. But if our client wants us to make that position, or look, we have a valid position, We looked at their future medical. We looked at what's disputed. We looked at their past treatment course, and we don't think there's going to be any need for future medical in this case. We take a position as a zero pay. Fine. We can defend that. I mean,
and is it worth getting those reports from the vendors then, where they kind of make the case for us?
sure. I am agnostic about whether that's a legal decision, a vendor decision, or just a client business decision. I'm agnostic about it. The reference guide doesn't really advocate for one over the other. I've for a long time said there's no reason that, lawyers on both sides can make to say, look, we don't think this is a necessary set aside, or setting a number. That's fine too. Like there's nothing in the reference guide or the statute that militates against that. And I think, reasonable people, particularly in a zero set aside where, what kind of injury are we talking about? A fracture, a laceration that's just not going to have future medical. Do something practical, maybe not worth the vendor's time and money. All right, other questions, thoughts? Okay, Mr. McLinden, this is going to be good.
Could you say something about the workflow? There is I believe the conditional payments, and it says a language about Medicare is sort of lien in this amount. A lot of times I see that kind of misdrafted. So that is where Medicare has already made conditional payments that they're saying we shouldn't have had to pay for this, and you have a statement that says that. So, and you can't say that's zero unless you get a conditional payment statement clearing it, right?
Correct.
Okay. So should we be removing that when we don't know that's applicable, or?
Yeah, I mean, if you have either two circumstances. One, Medicare comes back to you with a zero conditional payment letter. You'll see that. You take that right out, because you could take that right out of your settlement because it's zero, or you could put in your settlement. We asked Medicare if they had made any payments they consider conditional, and they said no. That's fine. Those are fine things to put in our settlement. But if you haven't made the inquiry, you're just making the presumption because we say, oh, the guy's not entitled yet, or for whatever other reason, take it out because they're conditional payments. That language doesn't even apply. It's not even a concept that we should be thinking about. Oh. Okay, Scott. All right, good. We got everyone's trying to stump me today. Let's go.
A little bit of a curveball for you. So I have a case right now. The carrier got a vendor calculated Medicare set aside. It came back, I think, is like a little over $12,000 or something like that. Put it in the settlement, submitted the settlement to the board. Settlement sat at the board for way too long. In the interim, the guy goes and gets emergency surgery for his back. So we sent a letter to the board basically saying, hey, process this Section 32 agreement. And they issued a response today saying the Medicare set aside is not high enough. So we're now in a position where we need to potentially get a new calculated Medicare set aside because now the board apparently is going to weigh in on these. So what do we do there?
Yeah. So think about what happened there. So we said we had a 32 plus a set aside, and then the board saw the treatment then occurs after that and probably realizes the bill for this treatment exceeds the money you had put in the set aside. I agree with the board. I mean, yes, we absolutely should have gotten a set aside recalculated. And I would also do a conditional payment search and make sure nothing got by accident billed to Medicare too.
I guess the interesting thing about it, though, is that there's no C8.1Bs or anything like that for this surgery that happens. So they're essentially assuming that either the carrier is going to deny it or what have you. But I just found it odd that the board actually weighed in on something that it usually doesn't. Let's put it that way.
Well, the board has an obligation to protect Medicare too. Right. And the judges have an obligation of the act. Every party in the settlement, including the state agency, has an obligation. So if anybody sees Medicare potentially being defrauded or potentially becoming obligated for treatment that is being foreclosed in the comp action, really everybody has the responsibility and obligation to stand up and protect Medicare. That's what's crazy about the Medicare Secondary Payer Act is it kind of seconds or obligates everyone. We all become Medicare's unpaid debt collectors in a weird way. Like we all have to do this, even though, we can't bill our time and attention for protecting Medicare's interest to Medicare. We have the obligation to do it and our clients have to pay for it. But even the board itself has the same obligation. If they see something that could potentially obligate Medicare, or, clearly that set aside, which didn't anticipate, presumably the guy was going to have the surgery. Then he goes and has it, and there's going to be all sorts of follow-on care, presumably from that surgery. And again, I guess the board also takes the presumption that it's compensable, because we're going to rule everything's compensable. So I think that's why they made that determination. It doesn't really surprise me, but it's unfortunate for your case. Yeah. If he had just settled it right before he did that shenanigan, that would have been helpful. All right. Okay. We have a question in the back. Corin. Yeah. So two things. I'll tell you two things. First thing is, on a conditional payment statement, so it's not a Medicare set aside, but a conditional payment statement, you will sometimes get them come back with all sorts of stuff on the conditional payment statement that is actually not related to your workers' comp case. You'll see they're getting treatment for male pattern baldness and chronic halitosis and all these other things. And you're like, well, that's not part of my comp case. And you can dispute it. I mean, we can stand up and say, look, we shouldn't have to pay for all those things, right? So that's one thing. But the second thing I would tell you is, too, it's very important when we're telling the client, hey, we need to consider Medicare's future interest. We're going to have to get a set aside proposed or a life care plan proposed so we can figure out how much money to put aside in this second bucket of money, the second envelope, to make sure the client knows exactly what's established in the case, right? It should only be for established body parts and for the body parts that we expect there to be future treatment for, that causally related established body parts. Not everything that's ever happened to this person. Yes, those vendor reports will come back with all their comorbidities and everything they've ever had treatment for, but it really should only consider what's in the workers' comp case. And particularly that's important with the Part D. I mean, we've all seen set-aside allocations come back where the medication component is super high because they believe they're going to be on this stuff forever, these medications forever, and they might also put in medications that are not related to the comp case. So those are two things that I would be really specific with my client. What are the causally related body parts? What's been established in my case? Because that's the only things we should be getting a set aside for. Okay. All right. Any other questions? Oh, Declan.
I was going to comment that potentially if there's any opportunity for weaning, that would be the time to do it before you get the MSA.
Yes. Two things. Weaning is important to think about because opiates, pain medications, you can get them off that stuff. It's going to reduce the MSA dramatically. The second thing you can try to do, particularly in your cases where the claimant's long-term oxy-dependent, get them onto the marijuanas. Okay, if you can get them to switch their pain to their little, nighttime gummies, if you can get them onto marijuana, marijuana is still scheduled drug. The federal government will not pay for marijuana treatments, will not pay for it, and they're saying they never will. So it's not on Part D. So even if you can get them from, a narcotic-based or opiate-based pain management regimen into a marijuana-based one, that can save you hundreds of thousands of dollars because you will not have to put money in your set-aside allocation for a drug that Medicare refuses to pay for, right? And then there's other circumstances too, like Medicare won't pay for anything experimental, right? Anything that's not FDA approved, et cetera. So, you could be kind of strategic about trying to push them into the alternative treatments. Okay. All right. Great question. Any other questions? All right. Scott's got the last one. I'm trying to let everybody go early, but those guys.
It's more of a comment, I guess, just kind of picking up where you were just saying. I had a situation where there was a guy taking an opioid and it was a name brand.
Yes.
And those name brand opioids are way more expensive than the generics that you can get.
Correct.
So I was able to work with claimant's counsel with the doctor to basically at least switch him off
to a generic.
That's
a great strategy.
It ended up saving like $350,000 for the lifetime. So if they won't go, as you said, on the marijuanas, see if maybe at least you can work with them to get them onto something that costs a lot less. There are other ways to get it down.
Agreed. Yep. And until Medicare Part D starts pricing at generics, because they don't price at generics unless the person's already on a generic. So that has a huge impact on your set aside. But they don't do that currently. All right. Any other questions? All right. Wonderful. Medicare secondary payer got a lot of feedback from the group. This is great. This is not an easy topic. I appreciate everyone. Thanks for joining in, and don't forget to rate your stuff. All right. Have a good day.